need to clarify. Ministry made a comprehensive presentation. I have certainly certain differences of opinion. I think in forums of this nature, I do not think we need to discuss about the minority. I will only read. I do not want to say anything except to know what the Supreme Court judgment has said. I will read out the Supreme Court judgment. I certainly have problems when nobody is talking about a minority judgment because Justice Gawai gave a minority judgment, and then Bella Trivedi also had certain difference of opinion. I have those difference of opinion. I've read comprehensively the Supreme Court judgment in the last 3-4 months. I have a copy of it. Let me read out the operative portion. I think as you have initially made your remark, Mr. Sridhar, we will only go by what the Supreme Court says. Number one, on August 1st, 2024, the 7-judge constitutional bench of the Supreme Court, if you have any difference of opinion, you have every right to intervene, sir. On August 1, 2024, a 7-judge constitutional bench of the Supreme Court upheld the validity of the homogeneity as they faced varying degrees of discrimination. Supreme Court has recognized that. There are varying degrees of discrimination. I'm quoting the Supreme Court, no interpretation. I think journalism, I don't want to interpret. Facts are facts. Facts are sacred. Supreme Court is sacred for me. The decision overrules the 5-judge bench decision of the court of E.V. Chennaiah versus State of Andhra Pradesh, which gave the judgment, as you have said, in 2004. Let me further say, it's very, very important for all of us to understand in perspective. Does Article 14 permit for classification? The Supreme Court, in the majority opinion, said yes. Under Article 14 endorses, I'm quoting the Supreme Court, parity of treatment under the parity of conditions, not sameness. Subclassification is a facet of equality and it is permissible. In the majority judgment. Majority judgment. And then, second, this is important for our discussion. Only 7 points I want to make. Number 2, are scheduled caste a homogeneous group? Supreme Court categorically in the 6-bench judgment said, no. Inclusion in the presidential list is not an indication of homogeneity. There is a historical evidence to suggest there are varying degrees of backwardness within the scheduled caste group. And Supreme Court has quoted 27 judgments on this issue. On perhaps even a little more. Then another important discussion which is required for us. Does subclassification amount to tinkering with presidential list? Very, very important for our discussion. Are we tinkering? As we very rightly pointed out, 341, we cannot exclude or include. Supreme Court in about 20 pages have very clearly said, no, it is not tinkering with 341. What is the Supreme Court said? The count of E.V. Chennaiah versus State of Andhra Pradesh incorrectly held that subclassification amounts to, according to the Supreme Court, amounts to tinkering with the presidential list. Subclassification now, the Supreme Court said, does not, I have a problem with my side. Subclassification does not entail inclusion or exclusion of caste from the presidential list, and therefore it is not tinkering. We are not changing. 341. One more point. Does Indians have any restricts classification? I think for our discussion, OBCs are not required because Indira Savani case only deals with OBCs. We're only talking about scheduled caste and scheduled tribes. Though my friend quoted extensively, that is only relating to OBCs. They did not look at SCs and STs. Now, one more important point. Do states have the power to create subclassification? Supreme Court examined this very, very comprehensively. Supreme Court said yes. The states have the power to create subclassification within the SC/ST under Article 14, 15, and 16, which are quoted quite extensively. Then comes last point. What are the limits for sub-classification? I'm quoting again the Supreme Court. Classification in which certain castes within the presidential list are excluded completely from the benefit of reservation. Are sub-classification subject to judicial review? I think he has made it very clear. Yes, Supreme Court says. States cannot act according to their whims and political interests, which it did not mention, but that is my worry. State cannot, whims and fancies and political interests, they cannot have it because recently we carried out a survey in Telangana. Earlier government also carried out another survey. There are some whims and fancies and political interests there. Let me read out the Supreme Court. Yes, states cannot act according to their whims and political interests. Any state legislation creating some sub-classification must be based on data and subject to judicial review. But what is important, I'll just take one point. The judgment talks about, this is slightly my interpretation, deepening of social justice. It talks about ensuring equality. It talks about ensuring diversity. Supreme Court also talks about suffering from historical and social disabilities and social discrimination. And Supreme Court also, as I have said, it is not a homogeneous group. Lastly, I will exactly quote what the Supreme Court says and then wind up. 6 of the 7 judges have now ruled that 2004 judgment was wrong. In his judgment on behalf of Justice Manoj Mishra, Chief Justice Chandrachud held that SC communities are not a homogeneous class as ruled by earlier judgment. He disagreed with the view that both of them have disagreed. 4 of them have agreed with them. That's a 6-judge judgment. He agreed with the view that the act notifying the list of SCs create a deemed fiction. They have used the word deemed fiction, that all of them have a similar status. In other words, it's fictional to think, it's fictitious, unrealistic to think that not all of them belong to the same group. He disagreed with the view that the act notifying the SCs create a deemed fiction and all of them have a similar status. Lastly, it is true that they have a common constitution, the identity as scheduled caste based and their experience of untouchability. And the Supreme Court talked about both of them on this caste based untouchability and discrimination, but that does not mean there is no heterogeneity. There is heterogeneity. That does not mean there is heterogeneity among them. He cited historical, empirical evidence, etc., then went about doing it. Lastly, the court permitted sub-classification of scheduled caste, but the state should have rational basis for doing it. Empirical, scientific, evidence-based. I do not want to quote several other judgments because he is already quoted. If you have any kind of a difference of opinion with me, I've very fairly, objectively quoted what the Supreme Court said without any interpretation. So my appeal is, let us not discuss the minority judgment. Minority is a minority judgment. It's a 6-1 judgment. Let us not discuss creamy layer, because in the Supreme Court they did not agree on a creamy layer. They only incidentally mentioned, if I may use that word, creamy layer is not of concern for us here. Then of course, in the backward classes there is a creamy layer. All of us are fighting that case. Myself, there is an appeal in the Supreme Court on the creamy layer issue. So this is what I want to say. Number 1, we will confine our discussion to 6-bench judgment, majority judgment, and what they have said, where they have discussed, or they have identified 6 issues which are important, crucial for a discussion. I will appreciate if discussion is confined to that. Then it becomes easy for us to move forward. When I get an opportunity, I will, because I've been interacting with these groups for the last 3-4 months, informally, formally, with the student, with the various groups. Then way forward comes, is there a solution? 100% there is a solution, provided we have commonality on these issues. Commonality on this issue. Lastly, I hope this discussion is going to be very, very harmonious, very, very academic. It is not acrimonious, because 10 discussions I've attended all over. I spoke 3 days ago in Lucknow where, majority of them did not agree with me. I don't want, this discussion to have that kind of nature. They are very, very distinguished advocates and distinguished professors, and we must find a solution. We can only find a solution provided, we agree on the majority judgment. Let's not get extraneous issues like trivial error, minority judgment, etc., etc. Then we'll be in a position to find a solution. I thank all of you for giving me this opportunity. I did not want to intervene. I only came to hear. I thought, I will learn. But then, when there's some kind of a, direction, a discussion takes place, I thought, I should try to intervene and make my point. Thank you very much.
Just actually clarify.